responsible for leading Sabre's Middle East organization, which includes overseeing acquisitions, joint ventures, corporate strategy, treasury activities, tax planning, accounting, reporting, auditing, and investor relations. Apart from handling routine company secretarial work, actively involved in corporate restructuring, dividends and distributions, intercompany arrangements, positions, he is also the advisor to the directors on their duties, responsibilities, and liabilities to ensure that they have this in mind when making decisions, building internal governance systems, controls, policies, and procedures around legal entity data. And our third speaker is Fayyaz Mahmood, General Counsel, Bahrain Airport Company. As Bahrain Airport Company's Chief Legal Advisor and Secretary of the Board of Directors, Mahmood is responsible for writing, reviewing, executing agreements and contracts for and on behalf of the BAC here in Bahrain, including licenses, leases, and other general business contracts, both domestically and internationally. In his capacity as Secretary to the Board of Directors, Mahmood prepares, writes, and files all minutes of the board's meetings and ensures all directors are monitored and complied with. So, the real Superman will go straight to our brother in arms. Just to let you know, what we're going to do is allow the speakers each to have up to 45 minutes as a group rather, and then 15 minutes for Q&A. If the group goes a little shorter, this is much appreciated because then we can allow for more questions and answers. So please have your questions ready, and the moderator will be our good friend, Aziz who is sitting on to the far side of the stage. He's co-chair with myself. My name is James McPherson, and we look forward to a good session. So over to Roberta.
Ladies and gentlemen, good morning. My name is Roberta Calarese. I've already been introduced, so I don't need to say more about my experience in the legal field. I think the thing that I would like to say as a lawyer is always make a disclaimer. My opinions and what I will talk about today are very pertinent to the journey that I have done. So I have worked in government for the last 12 years, and therefore some of the things I may say may not be applicable to you. I think the first point that we would like to touch upon is managing board expectations by anticipating conflict between executive interests and board interests. As a Chief Legal Officer, obviously I have an executive capacity. I work very, very closely with the Chief Executive Officer. I am also a member of the Executive Committee of the DIFC Authority. And so primarily what I do every day is I work for the DIFC. Now, it has happened in the past that my Chief Executive Officer, one of the Chief Executive Officers I've had, has said to me that I cannot meet the chairman without him being present. So I had to say, well, this obviously doesn't work. So the first thing that I think I would like to say in this particular circumstance is that it is very important to clarify the reporting lines. So I always make sure that if a new Chief Executive Officer is in place, he understands very clearly that I have an executive role, but at the same time, I am also the Secretary General of the Board of Directors, and that is an independent role from my executive role. It happens very often that there may be some conflicts between the two roles, and I'll talk a little bit about that, but I think that the important thing is to know which priority you need to follow at a particular point in time. And where you are stuck in a position, I think you then disclose the conflict both to the Chief Executive Officer and to the Chairman. So they're quite delicate. As a rule of thumb, I tend to follow the board before I do follow my executive role. And that's possibly also because the level and caliber of the board, but the board is the oversight and supervisory body of an organization. And so if something needs to be done and I am in a conflict, I think I would do first what is right for the board and disclose my conflict on the executive side. The other thing that I think is important is to be able to manage the roles independently. So you kind of have to wear two hats, and sometimes you will be acting on behalf of the board and you will have to be telling the Chief Executive Officer what to do. Sometimes you will be having on the executive and you will have to be advising the board what to do. I think the important part is, as a Chief Executive Officer, you really act as an advisor to the board. And in this region, I think this role has not developed so much. So when I was asked to become the Chief Legal Officer of the DRC Authority, and they did ask me to become the Secretary to the Board, I said, actually, I would rather not be the Secretary to the Board, I would rather just be an advisor to the Board. And the Chief Executive Officer said, in this region, we actually don't have General Counsel that are advisors to the Board. We have General Counsel that are company secretaries or secretaries to the Board. Mine is not a company, it's a statutory body. So I said, okay, but I play a very particular role. So I have my own assistant that does the administrative work of the Board, but I really act as an advisor to the Board. And over the last 4 years in the DIFCL Authority, I think the Board has learned that I am not there just as a secretary to the Board, but I'm really there to advise and guide the Board in terms of legal risks. And I think that that's very, very important if you are a General Counsel, and that you ensure that this should be the expectation of the Board and the role that you will play. The other interesting thing that I think I come across a lot in both being a secretary to the Board and the Chief Legal Officer is corporate governance. And I'm sure all of you have heard about corporate governance a lot. But I think what is best for an organization, very often, for example, I would have my Chief Executive Officer that wants to pass something through quickly, right? And he says, I would just go to the chairman and get it approved, And I always find that I have to bring back the expectation of my Chief Executive Officer to say, the chairman does not act alone. He does not have the power to approve matters on behalf of the company. The chairman is only there to represent the Board. And so, I've encountered this issue many, many times, and it's just making sure that you do manage those expectations. And I think when you're very familiar with corporate governance, you kind of know what to do. And so if there is an issue, I would just go back and I would speak to the chairman. I would just say, this is the issue. And my advice is that the matter should be presented to the Board. A very interesting example that I can give you relates to the bonus of the Chief Executive Officer, and who actually does the review on the performance of the Chief Executive Officer. I think very often people expect the Chief Executive Officer to be reviewed by the chairman alone. And I've been asked many times also at board meetings, it's like, who's responsible to do that, right? And I always advise that it is the responsibility of the Board to discuss the performance of the Chief Executive Officer. But then the chairman can deliver the message on behalf of the Board, but that discussion has to be done at Board level, and any remuneration or bonus has to be decided by the Board and not just by the chairman. I think the other thing that I would like to touch upon, and this is something that I feel very, very passionately about because I straddle across these positions. I am also the Vice President of the Italian Chamber of Commerce in the United Arab Emirates. I've been a board member there since 2007 and recently appointed as Vice President. I have been the Chairwoman of Art Dubai. So I kind of have a 360-degree view. So I have board member, I'm a Chief Legal Officer, and I am a Secretary of a board, right? So I think that what is essential and what you as General Counsels and Secretaries to the Board should expect is the quality of board papers. And I stop a lot of the board papers coming from the executive because I don't think they're good enough. And I don't think they present the relevant and right information for the board to make the right decisions. But what is interesting is very often I will not see this challenged by board members. And so in my capacity as board secretary, I do make sure that board members are presented with the right information. And this responsibility will then lie to you. I don't have to do that because ultimately it is the responsibility of the executive to present the papers they want. But I also know that as General Counsel and advisor to the board, I must make sure that this is done. So if there is anything that I would like you to take away today is really ensuring that the quality of board papers presented to the board are well structured. And this means from structuring, maybe as General Counsel you get involved in this role, is structuring board papers that then can be used, having a template, having the purpose of the paper, having the background to the paper, having issues that the board needs to consider, having clearly drafted resolutions that once the board papers are approved, the resolution stays there. I have seen board papers that have no resolutions at all, and it's like, okay, so what did the board agree? It's in the minutes. But if you write it down, I think that is very, very useful. The other interesting point, I think, is the role of the secretary to the board, stroke general counsel, as advisor to the chairman. I work very, very closely with my chairman. I spend a lot of time, and he very often asks me for things that I think, why is he asking me, right? I mean, this is really not much do. It could be real estate strategy or, you know, different matters, or to organize something on crowdfunding. And I think that that's an important role as a chief legal officer and secretary to the board, to be a trusted advisor to the chairman, because in that way, obviously, you have access to a lot of information that enables you to do your job better. So I think I would like to leave it at that. I think I've said enough, and then I'm sure that the floor will have a lot of questions, so I would be happy to answer. Thank you very much.
Good morning, everyone. First of all, I need to apologize for what appears that I came late, whereas I thought that the panel discussion was supposed to start at 9:30, so I was early according to my timetable, but late according to the timetable that the conference is following. My name is Fayyaz Mahmood, and I'm currently the General Counsel and Board Secretary of Bahrain Airport Company. And Bahrain Airport Company is the operator and manager of Bahrain International Airport. I'm sure some of you who've flown over from countries outside Bahrain must have gone through the airport. And in fact, Bahrain Airport Company was set up in 2008 as a result of a privatization process to commercialize the international airport here in Bahrain. And as I mentioned, I'm the General Counsel and the Board Secretary of Bahrain Airport Company. Prior to joining Bahrain Airport Company, I was the legal advisor and the Board Secretary to a company called Bahrain Mahmood-General Holding Company. And that's actually Bahrain's sovereign wealth fund. And in fact, Mahmood-General is the shareholder of Bahrain Airport Company. And prior to that, I'm actually a UK qualified lawyer, and prior to coming to Bahrain, I worked in another Gulf country, and before that I was working in the City of London as a corporate lawyer. And so the majority of my life has actually been spent in private practice. I've only been an in-house lawyer for the last 5 years or so, and but it's been my fortune, or perhaps misfortune, I've only worked with government-owned companies. And what I feel is that government-owned companies pose very specific challenges to general counsels and board secretaries. When I was at Mahmood-General, the board comprised 4 ministers, and my chairman was actually the Minister of Finance. And again, at Bahrain Airport Company, there's a high-powered board, and maybe the experience that I have with working with the government may not resonate with those individuals of you present here who are actually working with private companies. But I found working with government-owned companies to pose specific challenges, which are probably unique to those companies. I think one of the first challenges that I posed was because my chairman was the Minister of Finance. Gaining access to him was a challenge in itself. So I don't feel that the job of a board secretary when you're a part of a government company is as smooth as it is perhaps when you're working for a private company. There's so many protocols resolving around how one gains access to the minister, how one can discuss agenda items with him, how one can discuss the conduct of the meeting, issues regarding corporate governance. So I feel government-owned companies pose particular challenges. The other issue, of course, is that we are here in the Gulf, of course, and I assume a lot of you here are actually working in the Gulf, and corporate governance is very much of an evolving process at the moment. In Bahrain, for example, we have a code of corporate governance, and that applies primarily to banks and public companies, and there are a number of government-owned companies who have taken on the adherence to the code of corporate governance. as an optional decision. But again, corporate governance is still in an evolving process, and being the board secretary and the general counsel, I mean, general legal risk is residing within that particular combined role, and therefore enforcing corporate governance or showing the benefits to the company of corporate governance poses particular challenges here in the Gulf, which is still in a very evolutionary stage. Turning to the topic, which is the subject of the panel discussion, which is the real Superman, combining the role of General Counsel and Company Secretary for superior performance. I have some issues with this particular topic, because having qualified in the UK, I see a difference with the way the role of the General Counsel and the Company Secretary is in the UK versus perhaps somewhere in the US, or where it is currently evolving here in the Gulf. For example, if you take the FTSE 100 of companies based on market capitalization, there was a statistic that I was reading just the other day that in fact only 40% of those companies have combined the role of General Counsel and Company Secretary. 60% have a different person who's the General Counsel vis-a-vis the person who's the Company Secretary. And I think the reason for that statistic is obviously what is now considered to be the over-regulation of the UK market based on the financial crisis, the financial scandals that the world has seen over the last few years or so, and also the protective legislations which have been passed in respect of specifically public companies, where public companies in the UK are now required to have a qualified company secretary. And obviously private companies, those rules don't apply to that. But it seems to me that the role of the company secretary now is one which is now being specialized. It is one which is now being regulated, and that seems to be the way that things are likely to progress into the future. There is obviously a qualification, especially in Commonwealth countries, which is that of a chartered secretary. So you can actually go and be qualified as a company secretary. And there are a number of companies who require their company secretaries to be qualified. We don't have that requirement here in the Gulf yet. But maybe that's the way that things are going to be moving forward. So it seems that just because you're the General Counsel and the Company Secretary does not mean that you're necessarily being given superhuman powers and you're able to combine that role successfully. I think there's also disadvantages. I mean, if you take the US model, for example, there the General Counsel is very much more embedded in the business of the company. And the General Counsel in a lot of US companies is seen as being a part of the management team. And again, it seems that there's advantages and disadvantages to the UK versus the US model. I think that one of the disadvantages of having this separation of powers between the General Counsel and the Board Secretary is that obviously if the General Counsel is not the Board Secretary, then he doesn't have the opportunity to sit on the board, he doesn't have the opportunity to interact with the board, and therefore his involvement in the evolution of the risk strategy of the company is much, much less clear. I mean, where this role is combined, obviously there are then two reporting lines. If you're General Counsel and Corporate Secretary, as the General Counsel, you report to the CEO, and you're a part of the executive management team, and where you're also Board Secretary, you report to the Chairman. So I think that particular combined role is pretty unique within the company. I think that's only a role which is shared with the internal auditor, who will also report to the CEO and then also report to the Chairman and specifically the Board Audit Committee. It's really very difficult to go on either side of this divide. I think in the end it just boils down to the kind of company that we're in. What industry are you operating in? What is the size of the company? Can the company afford to have a different person as General Counsel, as different company secretary? I think obviously the bigger companies can afford to do that. and specifically the banks and the public companies. I think the smaller companies, if we look around in the Gulf, often you'll find the board secretary role combined with the CFO. And the other aspect, it appears to me that, again, practicing in the Gulf, is that sometimes the role of the board secretary is not actually taken very seriously. I mean, sometimes the board secretary is just seen as being a glorified minute taker. His job is to compile the board papers, communicate the agenda, sit in the meetings, take minutes, compile the minutes, have them put by the chairman, and then roll them out to the directors. So I think there's not one particular model that is in vogue at the moment. I think we have a different model being followed in the UK, we have a different one in the US, and a slightly different one here in the Gulf. And it seems to me that as the economies of the Gulf grow, it seems that we are very likely to move towards the US model, and as regulations become more and more severe in nature, we may move towards the UK model. But again, this is something really that the authorities here in the Gulf region, where corporate governance now seems to be taking on a much heavier role, will start to regulate the role of the company secretary much more closely to what is being done at the moment.
Thank you.
Thank you, Fayyaz. Good morning, ladies and gentlemen. I would agree with Fayyaz. He gave a right perspective in the UK that 40% of the companies now using the combined role of company secretary and the legal counsel. One thing is missing here is that over the period of the past 2 years, the roles have been shifted from 35 to 40. So it's not like that 60% of the company do not want to have it or they don't feel comfort. But it's because the role is evolving, that's why the company is shifting towards combining the two roles together. And this is, yes, the shift is very slow, made mostly because of the complexity. The rules and regulations around the world are changing on a daily basis, mostly. And it's becoming so complex that the companies feel really not very comfortable to combine these two roles together, especially in the larger size of the companies, where the company secretary himself has a major role to play, and the legal counsel is shouldering a big arm of the company. But what I'm doing here, I mean, this is a different perspective. It's not really very easy to debate the two lawyers sitting here. But the fact is that for the past 8 years, I'm the living example of the combined role together here. It's not really Middle East. I know many of my people, my friends working in US, also doing the same job, the combined role of the company secretary and the legal counsel. Let me give you an example. Generally what happened, the management of the company, the CEOs mostly, who are responsible for the overall company, they feel mostly comfortable having in-house lawyers rather than outsourcing this function to the third party, having a lawyer outside and work with the company on a case-to-case basis, on an opinion basis, or on a retainer basis. The main reason of the comfort zone having in-house lawyer is that the legal counsel in-house understands what's going on in the company. Most of the time, they are part of the executive team. They understand the culture, they understand the long-term objectives and the goals and the strategies of the company. This function is completely missing when we go to outsource. Every time, for every opinion, for everything, we need to go and try to explain right from the beginning till the end, and still, the culture part is missing. So, the CEOs generally feel comfortable if the cause of this company size allow them to have an in-house lawyer, the legal counsel employed by the company, so they live with the executive team on a daily basis. The same thing happened in the board. When the same question comes to the board, the legal counsel who doesn't sit in the board meeting, for them is an outsourced partner. Because for everything, they need a legal opinion. Either they go for the CEO, they ask CEOs or the company secretary to coordinate with the legal counsel and in the next board meeting come back with some answers. So that is for the board is as outsourced function, because they meet only periodically, they don't meet on a daily basis. They come, sit, decide about, they have a question on the legal, they don't have answer right in the meeting. Then the CEOs go back to the legal counsel, or the company secretary go back, coordinate with the legal counsel, and come back in the next meeting to answer. Now the board feel comfort to have in-house legal, which is the company secretary most of the time. So the general counsel and company secretary would combine together, and one person is sitting there. Board has a legal question, and the answer is right there, right sitting there. There is no outsourced function here. This comfort zone, I know I live with this for the past, like I say, 8 years, and I know that how board feel comfortable. Of course, the general counsel is not, general counsel's function cannot be taken over completely by the company secretary. But combining the role means that the company secretary and the general counsel work either closely together, or the general counsel, or what I promote normally is the general counsel become company secretary himself. That is resolving the problem, because the general counsel, the lawyer, cannot be trained in a few months' time. This is the time the lawyer is born normally, or he go through with the strenuous studies, education, training. So it's a long time that he takes that a lawyer to become a general counsel. The company secretary cannot become, if he's not a lawyer himself, cannot assume the role of general counsel overnight or over a short period of time. So ideally, the general counsel should come up and become a general company secretary also as an additional responsibility, and then he become a very effective super general counsel. But if he cannot, then the company secretary, like a CEO is sometimes not a salesman, sometimes he is not a CFO, but he is overall responsible. So he has people working for him. So if the combined role of the company secretary, where the company secretary is not a lawyer himself, but he can work closely together, because if the general counsel work closely with the company secretary. So the combination of the role effectively work in the companies, as far as my knowledge and my network of the people, and the board I'm sitting for over a year of time, I feel the board feel very comfortable when the company secretary himself is a general counsel. Thank you very much.
I think I would like to just touch upon some of the points that have been made, which I think it's important. The first thing is that strong relationship with the chairman and board members is essential. And my experience, I've been in the UAE now 14 years. I am a UAE national now, married to a UAE national, so obviously I'm not just seen as a foreigner, but it's the element of trust. And these are cultures that rely on trust, I think, much more than on merit. So if you really want to be part of guiding the direction of an organization, you need to build the trust relationship, and that can only be done with interaction. So I think I hear the comment that in some cases the role of the general counsel and company secretary should not be combined, but that only works. In the example that I gave you, when my chief executive officer said, "You want to be the company secretary?" I told him, "No, I want to be the advisor to the board." He said, "We don't have that. So you either are in or you're out." And they could have hired a board secretary, but I would not have been part of the board meetings. And I would not have built the trust relationships that I have with my chairman, with my board members, that I think allows me to be a much better general counsel. I think the essential thing to be able to properly advise on legal risk and reputational risk is having full information of the company. I also come from an American corporate background, so I started my career with Goldman Sachs. I worked with Prudential-based in investment banking, and I think that as general counsel, to be effective, you have to be part of the business. And I think it's up to you to drive that. You just cannot give legal advices and stop at that. I think you need to drive your role within the organization. The other thing that I wanted to mention is the qualification of chartered secretary. Whilst it's a nice qualification to have, I think being a chartered secretary is not rocket science, being a secretary to the board. So I think, like it was said before, you can be a lawyer and be a secretary. You can't be a secretary and become a lawyer, right, unless you do the whole path. So I think that if the answer is that you don't have access to the board, I think as general counsel you do the role as secretary to the board as well. And in terms of being a glorified minute taker, if you have the possibility, I don't take minutes. I mean, I review the minutes, I attend board meetings, but obviously I am very much involved in the discussions that happen at the board. So I always have one of my senior lawyers coming in. All board meetings are taped, and obviously if I have any questions or I don't remember when I'm revising the minutes, I'll go back, but I will get somebody to do the administrative part, so actually I can act as an advisor to the board. So it is a bit of a Superman role. You will be faced with conflicts, but I think being able to do them both is better than doing one only.
Yeah, I mean, I think basically there's obviously a cross-section of opinion on this, and I think it very much depends upon the personality of the person in whose those roles are being combined. I mean, for example, when I was working at Muntalakat and being an investment company, there was a transaction that I was working on, and I was personally involved in those transactions, and then I had to recommend them to the board. So, you know, I was put in a very, very difficult position because I expected the board to take a very independent view of those transactions prior to approving them. Whereas I myself were working with external counsel and having worked on those transactions, I had to recommend them to the board itself. So, you know, the role of the independence aspect of the board secretary's role when it's combined with the general counsel is one that needs to be very, very clearly defined. And you know, the board itself have to be, you know, understand, you know, you know, how lawyers operate, what are legal risks. So it's not just the general counsel becoming closer to the business, it's also the business people becoming closer to the legal role and understanding what that role actually is. So I think overall, I would say that the combination of the role of GC and board secretary is one which is a healthy one. It's a very powerful role, and it's becoming more and more powerful. But it needs to be exercised within the parameters of independence. There needs to be a proper corporate governance structure put in. I think the roles and duties of the corporate secretary versus the general counsel need to be defined. There needs to be proper charters in place. A board charter needs to be in place. The responsibility of directors need to be very clear. There need to be clear assessment of the directors' performance on an annual basis. They need to understand their roles, and I think as corporate governance becomes more entrenched within the Gulf region, all of these things will happen. And the other difficulty that I want to touch on is that a lot of business is conducted in the Gulf in the form of family businesses. And because of the peculiar nature of family businesses, corporate governance is something which you know, is in a very, very infancy approach, and basically the overarching power that the owner exercises over those businesses means that perhaps corporate governance is not actually followed to the extent that there may be. So basically I think these roles, the combination of these roles are very much dependent upon you know, close regulation.
Thank you. All right, so we're going to have some questions. Can we see some hands for people who might have questions for our learned friends? Please. And if you can give your name as well.
Abdul al-Houthi from Sultanate of Oman, Oman Arab Bank. Overall, I just understood that still the dilemma is going on. No, like a golden solution for these problems. It will be. I feel it's gonna be for another 10 years. We're gonna have the same issue. Who's gonna be the board secretary? In my country, actually, there is a regulation from central bank, for the bank, for instance. They recommend either the CFO, internal editor, or general counsel to be the secretary or board secretary. So it's optional. It's left to the banks. On the other hand, for public company, for the General Assembly meeting, also it's for the decision need to be approved by legal advisor. If you see this announcement in the newspaper often, and board secretary, as if, and they even mentioned that there is segregation in the post between the legal advisor and board secretary. Therefore, the debate is, it will be on, in my perspective, for the coming 10 years, unless there is a regulation and stand should be taken. And as you mentioned, it depends on the company and it's a big, medium enterprise, and so on. So usually it will, I recommend should be solve this debate through the regulation. You mentioned they're going toward general counsel to be combined with that post, but I don't see it in the near future. It depends on the organization itself. Do you think that we should recommend some changes in the regulation? Mainly the tendency to the CFO, as you mentioned, especially in the banks.
I think you are right, you're perfectly well, because over the period of past many years, I think decades, this is a general trend. The CFO assumed the role automatically as a company secretary. It's happening in the medium-sized company mostly, because they don't want to employ a company secretary as a full-time employee. So somebody has to take up as a second part, as an additional job. And CFO automatically is just taking this role. My opinion is the CFO has nothing to do with the company secretary work. There are two completely different functions.
Sorry, internal auditors.
Even the internal auditor, because the company secretary is a major role player in the governance part, which is the link between the company's general governance and the board. And he should be an independent person rather than an internal auditor or the CFO. Having a CFO as a company secretary itself, in my opinion, is a conflict of interest, seriously. Legal counsel is the most natural person to become a company secretary. Because all company secretary has to do is to take care of the legality of the company. Make sure.
In-house or legal in-house?
In-house is definitely a much better option. Outsourcing, that board doesn't feel comfortable somebody sitting from outside and sitting in the shareholders meeting, that's fine, that's no problem. Because shareholder also doesn't sit in the management, but the board and somebody outsider sitting throughout the board, it's not really a comfort zone for any board member. But the legal counsel, assuming a role of the general secretary, company secretary, is the most ideal situation to resolve this problem. But I also fully agree that unless the regulators come and put this condition in place, probably the companies will not change it. Because, see what happened, the main reason CFO is carrying on the company secretary role is the confidentiality of the numbers, of the financial reserves. CFO is the one who knows the result, he makes the results. So if he's becoming a company secretary and sitting in the board, so there is no third person who's looking at the numbers. It's just the same person who prepared the number, he's the company secretary and is sitting and telling the board. But there is a huge conflict of interest. CFO, whatever he's doing, who's monitoring him? The internal auditor, but he's never comes to the board. So if the company secretary is the general counsel of the company, it's a totally perfect solution for that. And the government need to understand this whole thing. And part of the corporate overall general governance in the country, they should make it the rule that the general counsel can be either the company secretary is an independent person, or a general counsel should become a company secretary and not any third person in the company.
Next question.
This is Raymond Makki from Qatar here, Mahmoud. I work as a general counsel and board secretary. I just want to, I fully agree with this gentleman that the role of the corporate secretary was not, is not normally well defined in the law itself. Even in the company's laws or company acts, you will not find a full-fledged set of principles organizing the role of the board secretary, and even also not organize the role of the general counsel itself. Whereas you will find a lot of articles and clauses in the company's acts and in the company's article of associations, organizing the role of, for example, the internal auditor and external auditor. You will not find this article organizing the role of the corporate secretary or even the in-house legal advisor. If the General Counsel is sitting in the board as a secretary, first, he is not a member of the board, and secondly, the board sometimes may take a decision which may be illegal or have some legal connotations. If here you don't have any act, you just record. If you are asked, you may give your answer. If you are not asked, you just take the decision as it is. How I think we should recommend here that this Superman role should effectively be defined in a very good way, even in the company's laws and in the corporate governance charters and in company's article of association. Normally you will find only 2 lines article in the company's article of association saying that the company will have a secretary who will record the minutes and keep the files. That's all. And I think the matter should be elaborated in a good way.
So it seems that both our learned friends are leaning towards regulation in some form.
No, I completely agree with Ibrahim. I completely agree with you, Ibrahim. I mean, the interesting thing is that, as I mentioned, there's a code of corporate governance in Bahrain now, which is being followed by the banks and the insurance companies and the public joint stock companies, and it refers to the requirement to have a company secretary. And what it also says is that the company secretary must have its responsibilities set out. So there's an opportunity there. But again, the corporate governance code for non-public companies is based on a sort of comply or explain principle. And it's very easy to explain away these things. So I think the way to go is really for the government to enact legislation to enshrine this role and to give it teeth and to enforce these particular powers. I think the other difficulty, of course, is that for many, many years here in the Gulf region, lawyers have been seen as being a bit of a luxury, actually, and their role has not ever been sort of, really very, they're seen as being something that, you go to when you're doing a big financial transaction where you need an external legal opinion. Otherwise, lawyers are just seen as being somebody who, will just complicate things, and they will make things more difficult, and they're to be avoided at all costs. And, this mentality has to change, actually. And another reason why that you find the role of the CFO and the board secretary being combined is simply because it's a matter of cost. I mean, every company will have a general manager of finance or a financial controller, but there are not many companies where the role of the in-house lawyer is actually established. And as long as lawyers, are seen as being people that you call upon when you go to jail, and not people that are involved and need to be at the heart of your business, you will always have this problem.
I think I have a slightly different view. Number one, I would like to address the point of the Chief Financial Officer. In my view, there is no conflict of the Chief Financial Officer being the Secretary to the Board. I do not think that it is a good fit because the Chief Financial Officer does not really follow regulations, understand applications of laws, and so is not really be able to advise the Board. But the same way the Chief Legal Officer is responsible for advising on legal matters, the Chief Financial Officer is responsible for advising on financial matters. So in the role of Board Secretary, I don't see a conflict, even though I think that the Chief Legal Officer is the right person to fulfill that role and not the Chief Financial Officer, because obviously he just doesn't have the relevant expertise to do the role of board secretary. On the issue of regulations, I actually don't agree that the role of the company secretary should be prescribed in regulations. If you look at UK companies law today, unless you are a public company, you are no longer required to have a corporate secretary. I think I am much more in the camp of comply or explain in terms of corporate governance requirements. I think it is very difficult to dictate absolutely everything that the company would do. I think the generally accepted principles of best practice in corporate governance are widely spread. You're able to look at codes that have been written in the US, in the UK. I think it is the responsibility of the shareholders to decide how they want to run their businesses. I'm not talking about public companies and financial institutions because they're obviously super regulated by other types, not just by your company's law. But if you're a normal company, I think that it is sufficient what is currently there in companies law. Shareholders should determine how they want their companies to be run. That should be prescribed in the articles. Clear mandate should be given to the board of directors, who then should implement their charter and how all of these kind of things operate. So I think that everything flows from the top, and I think over-regulation and over-prescription is something that today is stifling business in the world. So I have a slightly different view. Thank you.
Thank you. Last question from our sister, and then I was going to hold the tribunal. You can tell where I'm coming from. Our learned friends will be here during the break and the rest of the day, and you can interact. But please.
Good morning, everyone. Thank you, panel, for the discussion. I'm Maimouna Sulaimani, head of legal in Al-Aziz Islamic Bank, which is a bank in Oman. Actually, I'm coming from a jurisdiction where this discussion is not possible to take place because it's ruled out already, and I'm in favor of that ruling in my country, that the General Counsel should not at all, it's under commercial companies law in Oman, and for all listed company not to combine the General Counsel role with the company secretary role. The rationale given for that legislation was very straightforward and clear. Consultation process took place, and then we've learned throughout the experience from the other Gulf countries. Okay, I don't see the rationale actually. There is no consultation to rationalize. Whatever I've heard over here, with due respect, are personal opinion or individual preferences. And when people talk about cost of splitting the two, I can see that the salary scales and the assistant, the structure of teams, they would have 5 lawyers, one just taking minutes, one clerical. It's about the structure and hierarchy, to be honest with you. I'm trying to be honest. Okay, people want to hold as much as possible of a high hierarchy by combining them two and then have a team underneath. In the same situation, if a regulation is out to split, okay, eventually one of those who are under the hierarchy could be the secretary. I'll just reflect the case study of Oman, okay? Once this regulation was out, okay, all the, obviously the board secretary, okay, had in the hierarchy higher than the General Counsel. So once the regulation was out, he was forced to be equal to the General Counsel, and he had to just, it's a matter of shifting the box from General Counsel being below the board secretary to being on the same level. That's the only change I can see, because technically speaking, every General Counsel who combines board secretary would bring more legal people in his own structure. So it's a personal preference. I can see people, some of them have appetite to more information relating to the corporate. You can get that information without combining both, okay, by having committees which are formed by, I had a discussion with my colleague Dr. Abdul. They have a very nice model, which is, I think many institutions have, which is to have a forum which board functions that are reporting to the board with function report with the executive level, meeting up and sharing information, so we can solve that. But the conflict which we talk about when we speak of CFOs and others still exists when you combine these two, similarly. And then the outsource, okay, of legal resource. We can't assume that there is a conflict or that he's outsider. We cannot call him like that. There is ethical. This is a profession that put obligation over the external lawyer. Okay, when he's outsourced, he is on ethical oath to serve a client. So he is not conflict of interest as well. Why only have it's a solution to be general counsel with secretary? I don't think. I think the example, to just conclude, the example that Oman has adopted is very sufficient and more governance than the other suggested. Thank you.
I think I would have to just make a few comments. I'll pass the microphone. I think you are right in some of the points that you make, but the role of the company secretary or board secretary is to really advise the board on its adherence to the charter and how the conduct of board meetings are carried out. So it's a very defined and I think limited role. And it is not a role that requires great abilities and great knowledge and everything. I think that, and you could get absolutely a pure company secretary that works if you allow the general counsel then to participate on board meetings and to be able to advise the board on the real risks that affect the organization. Because on the board secretary role, there are no risks there. Yeah, some risks if you don't prepare proper papers or if you don't, give proper notice or whatever. But they're not fundamental risks. See, my value at the board is that I am able to advise board members on much larger and bigger risks that the board runs, that the organization runs, which has really nothing to do with my role as board secretary. But if I was not the board secretary, I would not be able to do that as well. So in an ideal world, if you had these two roles, that would work. I think in practice and in reality, I really don't know, for example, in the UAE, many companies that have the role that is split.
So just to conclude, that it seems as if boards generally had the general counsel as an ex officio person at the table, this would obviate some of the issue. And what's interesting too is how some executive committees don't have the general counsel on them, and even don't have the CEOs on them and so on, which is very difficult to sustain.
I think the other point, that I just wanted to mention is the issue of having an external person run the company secretary role. I mean, I'm not sure that works really well, because whilst, yes, they do have a duty of confidentiality, the point is that to really be able to advise, you need to understand the business and you need to be part of it. You need to interact with the executive management team. You need to know who the people are that you need to work with. If you're an external person, that becomes a really difficult task. So.
Thank you. So I think
General Counsel.
Judge Mohammed just wanted to make the world's shortest question, and then we will conclude and meet afterwards. So.
Thank you, Judge. My name is Muhammad Al-Nasser. I'm a judge from the Hashemite Kingdom of Jordan, currently resident to the government of Dubai Legal Department. My question is, in combining the role of the General Counsel and Company Secretary, how would you balance your legal obligation as an impartial legal counsel versus your role as a secretary, board secretary, especially to when you will be trusted to the extent that you will be considered by the board of directors as a partner in the decision making with respect to the business. So how would you balance both roles, especially that you have a legal obligation, professional obligation, ethical obligation to be impartial in giving your advice, and but however you are trusted in partnering your board of directors and giving them an advice from a commercial aspect. And is there any qualification required in this regard for you to be like to give sometimes, because you are trusted to the extent that you will be asked to give a commercial aspect of the for the decision makers?
I'm very happy to try and answer this question from a judge. Usually when I appear before a judge, I'm shaking, so I'm happy to be relaxed at the moment. I think to answer this question very, very quickly, it's a very difficult question to answer, in all honesty. I think generally, and that again, it goes to slightly the problem that lawyers have in combining the job of a company secretary, because lawyers are there primarily to give legal advice. So if I'm company secretary, they'll expect me to comment on the commercial aspects of a transaction. And it's a very, very difficult role to fulfill. I think in the end, all you can do is explain to the board of directors that you primarily are there to provide legal advice, that the commercial aspects need to be taken on board and understood from the commercial and the financial team. Because the difficulty I often found as lawyers that people tell me, shall I sign this document or not? I mean, that's not my job to tell people to sell them. My job is to give legal advice. And there's a fundamental misunderstanding of the role of the lawyer. And that becomes very acute when you're actually on the board itself, because because there's a difficulty with the accountability concept here. They want someone to tell them to do things so that when something goes wrong, then they can blame it on somebody. And this is the issue, actually. So I think, I think basically the lawyer has to make very clear that he's there to give legal advice, the commercial aspects are with the commercial team, and it's for the commercial team to actually propose this deal to the board of directors, and the board of directors have to take their own decision as to whether this is in the best interest, because then they are accountable to the shareholder and not the board secretary or the general counsel.
Right. So we'll have one last question because my learned friend has suggested it's a good idea.
Okay. This is Abdul Abbas from Saudi Arabia. My question just maybe slightly different or just more clarification regarding the conflicts between combining legal advisor role and secretary of the board. My question is that there is a conflict when there is a third man in the organization in the middle of the board and the chief executive officers. That is when the conflict or the complications comes when there is a managing directors. You will find very difficult to see how to run your roles as the legal advisors in the presence of this man or the general directors who is being always in the same premises of the CEO, and generally we do not find any difficulties to advise board or to advise CEO, because generally the board member or the chairman of the board member is not always in the premises. His office may be outside the premises or outside even the venue of the company, but the most difficult is that when you have a general managing director in the same premises, how to run your roles and how to advise the managing directors in the same time, how to advise the chief executive officers. Thank you.
I don't think this is a very difficult thing to do, because see, in organization, all the executive leadership team has a different defined role themselves. Right. The CEO has its own role. He needs an advice from the legal. He goes to the legal counsel. They give him legal advice, financial advice given by the CFO, and so on. The problem with the board is what we are discussing here is why we should combine the role of the general counsel and the company secretary, and shall we do it or not? My think is that the company secretary's role is a completely separate function. It has nothing to do with the legal. And legal counsel has a different function. It has nothing to do with the company secretary at all. They are two different functions. If a company is a public listed company and highly traded in the stock market, then the company secretary and his whole team has no time literally to do any other function, because it is highly regulating in the stock market. There are a lot of regulation, reporting requirement, shareholding happening, transferring happening every time, every other day. But we are talking about the other company which is not listed, is not publicly trading very actively. Then the company secretary's role is not a full-time job. This is very difficult for the management to justify. A company secretary role as a full-time. He's not working day and night for anything. So it has to be combined with something else. What is the natural person who can assume the responsibility of the company secretary with his other duties? Generally speaking, you can see normally is the CFO who assumes the responsibility, like I said before, that because he knows all the company information, if he assumed the company secretary role and sit in the board, then is a one person sitting in the board, which is a combination of the CFO and the company secretary. So there is no confidentiality issue surrounding with this, anything leaking out from the what happening in the board. My take is that the General Counsel is the more natural person to assume the responsibility rather than the CFO, because he knows the law. And the company secretary's role is to interpret sometimes the charter of the company to the board and say that you are exceeding authority or not exceeding authority. Or if the board says whether the company objectives allow me to do this kind of a function, or the new venture if they want to do it, who's responsible? Who can answer is the General Counsel. If he is the one who assumes the role of company secretary, the answer is right and then there. CFO cannot answer these questions. His role is completely different. That's why I'm just generally telling that the combination of the General Counsel assuming the role of the company secretary is a more natural combination of the two. But in a publicly listed trading, highly traded company, nobody can assume the role of the company secretary. He is run his own.
So just a couple of things to pick up the three of you were mentioning. One of them was the lack of resolution in submissions. Do you have the three of you, any strategies to address this, shall we say, widespread and all too often real situation? Have you got any strategies or tips for your colleagues about how to deal with that? So if a submission is made but there isn't a crafted and appropriate resolution included.
I think I don't allow the board paper to be submitted to the board, as simple as that. So, we have a very strict templates for board papers, and they have to be properly completed. I would send it back to the executive 3-4 times until I think is of the quality, an adequate quality to go to the board. And that's where I see that my role as board secretary is very, very important.
So gatekeeper and quality manager.
Yeah, and I think basically it's the process of management actually. A lot of the board papers are right. I make sure that on each agenda item the resolution goes out with the board pack. So we're basically focusing the minds of the directors on what it is that's being required of them. And of course they could choose not to pass a resolution or pass a different resolution. But at least when they're reviewing the papers, they know what it is that the management is asking for.
Okay. And then the other thing, what do you do with, because I canvassed a number of participants about some of these issues, do you have any strategies on unruly board members? That's a standalone topic.
I'll leave that one to you.
There's no regulation on the unruly.
I mean, none of you have unruly board members. I meant this is purely hypothetical.
Can we define unruly?
Well, actually, it usually bleeds into another category, which is many boards are dominated to broaden something Fayyaz said, by lawyers. And many boards' lawyers have a very expansive view of their area of expertise beyond what they actually know. So the question is, and this applies to many boards around the world, so if you have a board member who is negative or acidic, toxic if you will, or if that board member has a broadened view of what they know, and you know that some of the other people on the table may not realize this person is, I don't want to say fabricating, but is taking license with their general experience.
Well, there is no rule on that, and then it happens, you're right, and sometimes, especially with the board, where there are institutional representatives in the board. So, for example, a company is having a shareholder from various other institutions holding the share, and they send their representative as a board member, as a part of the board. Sometimes these board members, because they are not really having a flavor of the company's business going on, they come up with their own ideas, especially if they are coming from different companies, and they have issues on those companies, and then they bring those issues into this company for no reason. So, yes, the conflict, I don't call it unruly, but I say some of the board members always have the conflicts in the board. I think the problem has to be resolved within the board, by the board, other board member. This is not a job of the company secretary or the CEO to resolve or control the unruly board member or the board member who's keep on bringing the conflict. It's the job of the other board members to manage and handle the situation.
Also the personality of the chairman. Also the personality of the chairman is very important because you'll always find within a group of people one person more dominant than another. And it's all about, the pre-meeting discussions which take place between the board secretary and the chairman. If there's an issue with a particular director being, if you want to call it unruly or just difficult, then it's something which needs to be discussed between the board secretary and the chairman prior to the meeting itself as to how, a difficult personality is to be handled.
I think really the responsibility would be for the chairman to resolve that. He's the person responsible for leading the board. I don't think it's a responsibility of other directors. I mean, they can raise the issue with the chairman, but issues like this would be picked up by the chairman directly with the other board members.
The third topic that was brought to me by people here was this question of auditing meetings. If you have, how do you deal with if you want certain senior management to be there for certain portions of the meeting, or if you feel that there's a very large new shift in some way? What's your experience been, and how do you manage having non-board members auditing, as in sitting in on the session?
I'll give my view and then I'll let my colleagues speak for themselves. I think that best practice dictates that senior management attend board meeting, because obviously it's part of what an organization does. Everybody should be informed, and I think things should be transparent. So, senior management should be aware of what goes on in an organization. So we always have all the executive committee members, myself, the chief financial officer, and the chief strategy and business development officer. We attend together with the chief executive officer. If the board wants to have closed sessions, they would just ask us to recuse ourselves. Very often they will ask the chief executive officer to recuse themselves, and they will have closed door board meetings. So as a secretary, they can ask me to stay. In some cases, they will ask me to go if it is a very confidential matter, and then they will just report to me what they want me to minute in the minutes. So this is, I think, best practice.
Yes, we're currently working on an airport expansion actually at Bahrain International Airport, and we have a number of advisors, and we have a very big infrastructure development department, and there's a requirement to give updates to the board on a fairly regular basis, and that can only be given by the concerned vice president. But again, it's very much sort of cherry picking really. This chap comes in and he delivers his update, he's questioned by the board, and then he leaves the meeting. And again, it's very much for the board secretary to, along with the chairman, to regulate the conduct of meetings and the presence of management team members.
And maybe one of the things that Roberta opened with was about taping meetings. Just to close on that, because I think that if you digitally audio videotape board meetings, it can be a very positive influence on how people communicate and present themselves. But at the same time, there might be some issues related to this sort of a record existing. So as the last point, did you want to have a comment on that?
Okay. I would not tape the meeting, simple as that. That's why the minutes have been taken, just because there's no need for whatever is happening in the board meeting, whatever the discussion happening, needs to go outside of the meeting. There is no need. There are a lot of discussion happens, which eventually sometimes drops. So you don't want to have the discussion leaking out of the board meeting, boardroom, and the other executives know about it. Sometimes it is really not to happen. The board minutes are only to record relevant things, which can be used as a reference in the future. So that's the purpose of the board meeting, and the videotaping or even voice recording. My personal opinion, that should not be the case.
Finish. Sorry.
Yeah, my experience of working in government companies is that it's not permitted. When I joined Mumtalakat, the chairman made very clear that he would not allow any meeting to be taped or recorded. I think the other issue really is a legal issue, because these tapes are then kept, they become a company document, and then they could be called into evidence. The other issue, of course, is that there's a perception that it prevents people from freely speaking their mind. And as has been mentioned, the minutes are supposed to faithfully record the deliberations and the resolutions. But it seems to me that, for example, I've been advising joint ventures, and in certain joint ventures, when there are the possibility of disputes arising, one joint venture partner insists that the discussions are taped, and there's no rule preventing that from taking place, provided you disclose to the other party that the meeting is being taped?
I think just very quickly, we do tape meetings for the very reason that we have very long board meetings, we have very complicated board meetings, we discuss a lot of issues of strategy, of policy, and what's so amazing is that first of all, you can't record everything sitting down and just listen to so many discussions going back and forth, and then people's recollections of board meetings sometimes differ completely even though they attended the very same board meeting. So what we do as a practice is we tape meetings for the purposes of taking accurate minutes. Our minutes are decision minutes that record relevant information. They're not verbatim minutes. Once the minutes have been signed off by the chairman and by the board, the tapes actually get destroyed. So the only record that remains is the minutes that we believe are as accurate as they can be.
Very good. Well, thank you very much, Roberta, Fayyaz, and Abdul. And we will now have a shift of the guard, and I'll turn this over to my co-chair, Mr. Nasib Abu Khia. Thank you to all the speakers.
Good morning, everyone, and thank you, James. My name is Nasib Abu Khia. I'm the General Counsel for Yahoo in the Middle East and Africa, and I also do public